Okay, so we just finished with our discussion on common law liability. Now we're going to get into some of the statutory law liability. An important piece of that statutory uh, liability relates to the Securities Act of 1933. So the Securities Act of 1933, again, comes out of laws that were designed to help reform Wall Street after the Great Crash and as part of the Great Depression to try and reform the entire financial system in the United States. And there's a lot that's in the Securities Act of 1933, but the 1933 Act regulates initial issuance of securities by registrants for publicly traded securities. That is, when you do an initial public offering, this is the law that governs the issues related to an IPO. You're required as part of that to file what's called a registration statement with the SEC that includes audited financials, and that's where the auditor's liability becomes a part of this. So under Section 11 of the Securities Act of 1933, if someone is going to sue you as part of an IPO for your role related to the audited financial statements, they are only required to prove two things. So as opposed to all of these others where we saw a number of things that they need to prove, they only need to prove two things. One, that there was a material misrepresentation or omission. So there's something materially wrong with the financial statements. And two, they suffered a loss. In other words, they purchased the securities. So if we take a step back and we think about this, loss or injury is always going to be present, right? People are not going to bring a suit unless they've suffered a loss. They're not going to just do it for their health. They had to have lost some money. So two is going to be demonstrated. That's not even a question. The real question is whether there's material misrepresentation or omission. So what you can see from this is this greatly expands the auditor's liability with regard to audited financial statements for their portion of that registration statement, which is the audited financial statements, because all that the party that is bringing suit has to prove is that there's something materially wrong with the financial statements. So there's no need to show any kind of reliance on the financial statements. They don't have to prove that they even read the financial statements. They don't have to prove that the loss was caused by the financial statements. All they have to prove is that there was a material misrepresentation or omission in the financial statements. So, because of this, the burden of proof shifts from the plaintiff to the defendant in this case, which is the auditor. And this is unique as it relates to American jurisprudence. In general, and overwhelmingly, what is the case is that the party that's bringing suit has to prove that you've done something wrong. Whether we're talking about criminal liability or civil liability, the plaintiff has to prove. And for this particular law, for Section 11 of 1933, it's not that way. Basically, the auditor in this situation has to prove that there is no material misrepresentation or omission. They have to prove that they're innocent, which is a departure from what we normally think of. So, auditors are responsible for material misrepresentations or omissions. Escott v. Barkris Construction Corporation, auditors were held liable for failure to conduct reasonable investigation, ordinary negligence. So, you were liable for ordinary negligence under the 1933 Act. So, what are some possible defenses? Always one of them is non-negligent performance, right? You did the audit in accordance with GAS. You could also possibly argue causation, that the loss that the people suffered had nothing to do with the registration statement, that in fact it was caused by something else, but that's a much more precarious defense because the a element of proof under the 1933 Act isn't that the loss was caused by the materially misstated financial statements, just that there was a material misrepresentation or omission. Short answer. So, how does the Securities Act 1933, which imposes civil liability for misrepresentations or omissions of material facts in a registration statement, expand the auditor's liability beyond that of common law? One, privity is not an element of proof. So because of that, and we're talking about a publicly traded or issued security, now you're potentially liable to millions of people, as opposed to just even foreseeable third parties. It could be anyone who purchased the security and lost money as a result. So there are potentially millions of plaintiffs. Reliance is not a necessary element of proof, which is a big one. So they do not have to prove that they use the financial statements to make their decision, which is necessarily if you go back and you look at the other elements of proof under common law, which either proximate cause or reliance was always required. And so because of that, the burden of proof shifts from the plaintiff to the auditor or the defendant in the case. To be successful in a civil action under Section 11 of the Securities Act of 1933 concerning liability for misleading registration statement, the plaintiff must prove, and again, it's just materiality and injury. That's it. So the answer for this one is going to be no and no. You do not need to prove any kind of intent, and you do not need to prove reliance. So that is it for the Securities Act of 1933.